We are recording. It is Thursday, October 28th, 2021 at 10 a.m. This is a public deliberation of the Baltimore County Board of Appeals in case number 21076A, a petition for variance relief in the matter of Security Boulevard Ventures, LLC, for Patapsco, Glen 2, 7726 Johnny Cake Road in the First Councilmanic District. There were 8 variances originally applied for. Not all of them were in play at the time of the hearing officer hearing below, the ALJ hearing. And I found there were any number of issues in the determination by the ALJ to grant or deny different variances in this case. In particular, and let me back up. In trying to look at these carefully, I listened to the hearing below, which we now have the opportunity to do because it's recorded on WebEx. I also, in addition to reading the ALJ opinion, went back to Patapsco Glen 1 to both the decision on those variances by the ALJ who denied them and by this board before my time. And found many of the same concerns that were raised. And in general, found that the petitioner's expert talked about the overall constraints on the site, namely the gas line, the road configuration, underlying rock, environmental features to justify all the variances. And in the case, just like in the case for Patapsco Glen 1, where the variances were denied, there was no testimony expressly tying each variance to a particular condition on the site that mandated that variance. However, in the Board of Appeals decision, there was express language, which I will be happy to quote for you, that there was testimony at that level tying each requested variance to a particular condition that mandated it. I happen to think that is essential testimony that was missing, except in the case of the rear-loaded lots where the garage was in the back, which required a variance of the yard and distances. And that's a peculiar quality of the buildings, of the structures that would warrant relief. But if you look at the variance plan, go through them, those justifications as to the particular site condition supporting each variance, I did not hear in the testimony below. I understand why the site is constrained and why it is preferable to put whatever units they're putting in the area south of the gas line. But I did not hear particular justification. And that is particularly as to what they identify as variances 1, 3, and 5. The other thing I note is that the area north of the gas line, by their own experts' testimony, is largely undevelopable and constrained by environmental conditions and underlying rock. So to use undevelopable land as a justification for not building for as a unique condition, a little self-serving, but so that's where I would start. And I have a lot more notes and a lot more cases to talk about these. So, Mr. Belt, you're muted.
I'm going to defer to Fred first here, Mr. Lauer.
Okay, Madam Chair. I looked through the various variances also, and would surely agree with you regarding the one that planning recommended related to the rear entered property, or that one for sure. But in general, I mean, I looked at the gas line, I looked at the tree itself, you know, and keeping the tree, and some of these were requests by the community, and that's kind of hard to weigh in here in some ways, because, you know, on one side, I feel the community has a right to have input and suggestions and make things, but in doing that, you know, are they creating some of the difficulty, if you will, in terms of developing the land? And, you know, take the tree out, what's the difference? How does that make any difference here? But I looked at the gas line, the tree, I looked at the bend in the road, the arguments that were made by the developer and the attorney, of course, the pumping station and the forest buffer. Yes, my overall feeling was that combination of those things does create a uniqueness with this property, as was argued. Combine that with the community request and not being developable above the gas line, and planning's request in terms of certain things. You know, I'd like to hear more what both of you have to say, but my general feeling is that the property, that this combination of those things creates that uniqueness, therefore the practical difficulty in developing the property. And I believe they're at 250 units now, as opposed to 296, if my numbers are correct. But we all heard the argument that the numbers have been reduced because of that difficulty in getting it out. So that's my initial take. I'd love to hear more from Mr. Bell and from you, Madam Chair.
I don't disagree that there are unique characteristics that limit the petitioner's ability to fit 296 units, the permitted density on the property. But our standard is whether compliance would unreasonably prevent use for a permitted purpose, not to maximize density.
Sure.
And for instance, in the case of B1, I think it affects 3 units. Not sure if it's where there, I guess it's V5 allows 7 units in a row in lieu of the permitted 6. I found no environmental condition or that would mandate where that has that effect, where the regulations create a practical difficulty. Again, you're talking about 3 or 4 units. And then we also have, as part of our standard, whether a lesser relaxation than that requested would still give substantial justice to the applicant. And in those 3 cases, V1, V3, V5, I think they've asked for, they could have not sought those variances and still been able to develop the property in a meaningful way. And the petitioner's argument that denying those variances would force redesign into the area north of the gas line, where the area is largely unusable anyway, I thought was a little, I found it not credible, where to abandon these variances that just jam up the site without tying them to a particular condition does not defeat the use of the property in a meaningful way. My view, you may disagree. Mr. Belt, are you ready to chime in?
I shall chime. I guess I have all kinds of conflicting feelings on the matter, and I believe Ms. Dobkin's statutory and case law strict construction is absolutely proper when doing a fact by fact basis. But what I often struggle with is whether we have a more global view of the variance or a strict constructionist. And one thing I always think is a point to bring up is that, BCZR 307.1, which, that defines the variance. Board may grant a variance where special circumstances or conditions exist that are peculiar to the land or structure, which is the subject of the variance request, and where strict compliance with the zoning regulations for Baltimore County would result in practical difficulty or unreasonable hardship. So what's always kind of blown my mind, to use a term, is that it always was my thought that we use case law to interpret statutes. But it seems that we're always now using the statute to try to figure out what in the world the case law was saying, which I think is backwards. So with Cromwell, with the term unique itself, it's always been confusing because it's clear it's not the dictionary meaning that's being applied. And another thing that's also never applied is the geographic area of the surrounding property to make the comparison. And I've found in other cases, say in a housing complex, just because a house has a slope and there's 4 others that have a bad slope, some would say, well, it's not unique because there's 3 others. And to me, that defeats the purpose of what was meant about being unique. Well, if we were to do a strict construction of a unique, it'd have to be just the one. Only one person in the whole place could get a variance, because after that, it wouldn't be unique. So based on that explaining, I have a more tolerant and global view of what can be unique in the area and what that means. And I defer more to the definition. I think what Ms. Dobkin is saying, and just to be clear, the record that I believe we're going by is not the AOJ record, because since it was de novo, it would have been the testimony that we heard on the day that we heard this. So any tie between the unique factors and the individual connections would have to be made at that hearing, the hearing that we had before this board. I was more satisfied in a broad sense that the description, gas line, pumping station, and things in the northern part of the property laid out a nexus per se. Where's my next thought going? Oh, my third thought here, and this is a unique problem to me, is that I am one of the signatories of the first case.
Well, I want to chime in there.
Yeah.
If you go to page 8 of that decision,
Yes.
as noted above, not all units require the same variance relief. The conditions outlined above affect parts of the site in varying ways and in varying combinations. Moreover, petitioners have proved that the same conditions that lead to the conclusion that the site in general is unique also require the same particularized finding for the individual units and or groupings affected by one or more of those conditions. To be clear, the uniqueness of one part of a property does not necessarily extend to other parts of the property. In this case, petitioners have identified the conditions experienced at different parts of the property. In doing so, petitioners have presented sufficient evidence that establishes that certain characteristics render parts of the property unique for one or more reasons, and therefore have gone beyond a general showing for the site to justify an analysis practical difficulty to develop each part of the property as relevant. In turn, petitioners have carefully targeted the requested variance relief to match the various conditions found, so that they were very apparently specific.
Well, as I recall, unfortunately, I don't recall it all, but I think one influence of this decision was that this was basically a proffer. And there, at least at the board level, there was not opposition to those variances, which pretty much, when I look at them, variance for variance, are pretty close to what we have here today. And then I also was Mr. Lauer's point too, for me, and again, this has nothing to do with Cromwell, it has nothing to do with a variance analysis, but I guess a matter of just, I don't know, fairness, some sort of equity, is that some of these variances came as a result of accommodations made to folks in discussions to move things away from certain parts of the property, and doing so facilitated the need for some of the variances. So that is not listed in any variance analysis, but I can't say I'm blind to that factor as being interesting, and also in keeping with the fact that we do have the first development, which is quite similar, that was afforded these things. But I also understand Ms. Dobkin's strict constructionist that she believes you must be more specific as cause and effect, I guess you could say. But I'm kind of hung up just on the equity of the matter when you make accommodations for the county, for other persons in meetings and such, and then you're brought to this point here that, you know, then we deny the variances. So I'm still at a loss. So I don't know if anybody wants to add some more about how they feel about the matter.
Well,
How about this, Ms. Dobkin? Just as a practical sense, I don't, if you're not prepared to do this, I don't want to make you do it, but is there specific variances that you feel have a proper nexus that would pass SNF using your analysis?
well, as I said, the variances regarding the rear V2 rear building face, um, and V7, which affect the rear loaded units for the most part and achieve some consistency, are justified by the building design, which was amply explained at the hearing before us as being rear loaded, and therefore the current, that building feature is peculiar to those structures. And that to me was more thoroughly explored, explained, justified the impact of the regulations, and that the, obviously, is often the case, the regulations have not been amended to keep up with current architectural design practice and market features. So the buildings have adopted those architectural features. And to me, that justifies it.
And that was also in conjunction with the fact that the having the shorter drives was actually an environmental plus.
Exactly.
Less macadam. If it was strict
Correct.
compliance, you would have very long driveways that would just create other problems.
Correct.
So I guess the alternative, so we still have the decks running around here. So to me, that's a whole nother feature here. So let me jump on board to eliminate it out of the thing. Though I see that there's no harm, no foul with the decks, I'd have to concur that I don't believe there's any uniqueness in the world that requires the deck factor. I think that's something that someone else has to address at a different time. So if you want to just get rid of the decks and go back to the things we still have to agree on, at least we can make some progress and at least, what's that, number 8?
Number 8 is the blanket variance for decks to extend further.
Yeah. I think Mr. Lauer's on board with that too, because planning was on board with that too. Planning kind of, in the testimony that I saw below, that's not before this board and this, but was in the development plan. Planning was kind of sort of tepid, but not really worrying much about the variances, but for that one, because they saw the variances sort of, come in part and parcel. But there's no testimony before us as to this matter. But this as to the comments, I believe that they were not in support of that. So let's remove 8 and go back to the fact and the RTA was withdrawn, so we don't have the RTA to deal with, correct?
Correct.
So actually, we're just dealing with 5. Is that correct?
V1, V2, V3, V5, and V7. Yes.
And do we still have the specimen tree issue? I believe at the end of the ALJ decision, there was the issue as to the trees.
The specimen tree needing, there was a special variance for it.
Yeah.
I thought that was presented and justified to preserve that tree and ample protections,
Yeah, so we have no issue there either.
no issue.
No, all right. I'm just trying to be a winner. I'm trying to see what we can win on. So, all right. So we at least made decisions on those. Okay. So now we just have, we say 2, 4, 6, and 7.
1, 2, 3, 5, and 7. And 2 and 7 are the ones that affect the rear yards as I see it. Variance 1 affects corner distances to street for corner units. Variance 3, I think, is a building to building separation. And variance 5 is putting 7 units together instead of 6. And I just think they're not justified. They overcrowd. They affect generally a very few number of units. And they weren't tied to any specific condition that would justify it. I mean, as far as I'm concerned, they're just overcrowding. But that's why we have these deliberations. But I would say we should grant 2 and 7.
2 and 7. Bear with me just for a moment. I'm trying to get a proper list before being what I needed.
Mr. Lauer, are you talking to us?
I would agree with you. I'm sorry, Madam Chair. I would agree with you with 2 and 7, and then maybe we can narrow it down to 1, 3, and 5, and kind of see where we are.
Now, for me, for 5, I believe the testimony nexus as to the 5 for me was which goes back to the testimony and the argument about why they're not putting things up in the north part. They had reduced the amount there and then moved for an extension to put more units down at the bottom. Though I know it's not a specific nexus that Ms. Dobkin might agree with, but I believe their testimony tied those things together, whether you accept it as being valid or not. I find it to be sufficiently valid from a global standpoint, just because of the testimony as to what accommodations were made to move the actual development. So I'm still feeling 5, but let's go to the other. Mr. Lauer, what's your thought on 5, sir?
I'm still kind of up in the air here. I think the 7 units probably are needed for in terms of getting the number. I mean, to be realistic about this, I mean, we all know that you have to make a certain number in terms of making a property developable, and they're down where they are, and these 7 units probably rather than 6 make a difference here. And the uniqueness of the property, to me, drives that extension of 6 to 7, if you will. So I would be in general in support of 7 units instead of 6.
So economics should not drive our decision. In fact,
I understand, Madam Chair, but
okay, just
yeah.
saying.
Yeah. And it doesn't drive my decision, but it does the uniqueness of the property and the constraints that are placed by the community, as was stated, make it difficult to develop this property if in fact maybe you can't do the development. So my feeling would be to support the 7 units instead of the 6 because of the constraints and the practical difficulty created by the uniqueness of the property.
So, Ms. Dalkin, number 1.
If you look at Developers Exhibit 9, you'll see this affects 3 units.
Just because of the shape of the shape of the lot, it only does 3.
Other corner units where they're closer to the road than is permitted, and they also, in most of those cases, have a smaller building to building separation than is required. And I found no testimony before us other than the general testimony that would support that. And once again, I think it crowds the site where the impact on the overall density is minimal.
Well, let me bring up another point again. It's not in the Cromwell analysis per se, but it's an issue that comes up, and it came up both in planning and also came up in the ALJ's decision. And the issue of the fact that these are contained variances, meaning that like this type of situation here, the only first getting to the justice standpoint, using the justice situation of it, there is, as for say this variance, other than this development, can we foresee any other resident being aggrieved by the 13 feet instead of 25, other than those buying in this development? Is that am I missing something? Meaning that, is there a neighbor across the street or anything other than this development that would deal with the effects, looking at the justice language that we've used in some of our definitions of variances? I'm throwing that out there because, again, that was something that I had considered too. Maybe I'm wrong. Deborah, is there any other developments other than this that would, apart from the analysis, be at least even facing this type of frontage?
Well, one of them is, I believe, let me pull my, not having a full-size plan makes all of this so challenging. Somewhere I have the plan. One of them is quite close to Patapsco Glen 1, but that would not be, but they're all,
I mean, Patapsco Glen 1 is,
for the most part, they're all interior
yeah, and
to the
well,
development, but to me, that defeats having standards.
right.
I mean, and I think it's going to be a beautiful development. You've got a good builder, you've got a good developer, you've got good landscaping and nice amenities. Like these need to be more substantially supported. I don't want to erode these regulations because one owner or one developer controls the adjoining property and this property. There's language in, I want to say, Dan Mountain that directly goes to that issue. But we don't write the regs. If it were a different zone, it might play out differently. If it were procedurally presented differently, it might give us a different standard. Just
Deb, you could
we're
remind me,
supposed to grant these sparingly.
could you remind me which ones we have left? We have one left.
1,
And
3, and 1 and 3. You and Mr. Lauer both seem inclined to grant 5, which is 7 townhouses rather than 6.
all right, so we're at 1 and 3 is what we're parsing on. Mr. Lauer, did you hear my sort of poorly worded thought concerning the contained manner of these variances?
Yes, I guess my feeling is these internal variances, I just don't see them having an effect on anyone outside of this area. And to me, it's kind of a balance in terms of variances. You know, if I have a piece of property and I'm need a variance from the property lines to build, the neighbor next door is affected, you know? And that's what I usually think of in terms of thinking of variances and practical difficulty and uniqueness and et cetera, et cetera. But in a case like this, the internal variances don't concern me as much. Maybe there's a different standard. I don't know if that's what you're kind of talking about, Mr. Belt, or your reference here. But to me, you know, I just these internal variances, unless it's something really outlandish, seem to me in the overall development plan, development idea, to make number one make sense, and number two to be legally justified because of, again, that broader scope, if you will, of uniqueness that's created on the property. So I would weigh in and tend to grant the internal variances, if you will.
Well, I think Ms. Dobkin's valid point, and something we always have to consider too, is tell me if I'm misconstruing what you're saying, Ms. Dobkin, is this basically the slippery slope nature of weakening strict construction of standards could cause further erosion of standards. And I think that's really a valid point. And I'm twisted up about that as well, but I'm also, as I started in Mr. Lauer's way of thinking, because I mean, ultimately, the reason for these variance requirements is for a modicum of protection of certain standards in a given area. If you look at that as that's the ill that's trying to be cured in a specific circumstance. And I think it's clear in this circumstance, practically, that the variance relief in 1 and 3 basically are just for the design of basically a design of the development itself, in keeping with the housing types and things of that sort. And I hear what Ms. Dobkin's saying too. If that's the case, we really probably would benefit from some more specific testimony that could give us the reasons for that. As I understood the testimony was that we're basically, I don't know, putting the square peg into the round hole, and how can we move it around due to the limitations on the site, some by natural features, other by utility features. And this is what we've come up generally using it more as a blanket statement. So,
By the way, go ahead, finish. I have a question.
all right. Then again, I go back to the matter of board consistency, but more importantly, personal consistency. And I think I am uniquely situated that perhaps if in fact I had not been on the first development, and I can say how the facts were presented were quite different than the one in this one due to lack of opposition, that I might be much more inclined to be adamant about Ms. Dobkin's scholarly interpretation of these roles rather than my more practical. While the board is not bound by prior board decisions, and though it's not put in stone for one's personal integrity, I find myself more so bound by my own. Um, and that is helpful just for when folks coming before us um, can have some faith in the conviction of what we're saying. So, based on that factor and all the factors we put before, this is such a close call. I think I am more, as a matter of me as a board member, inclined to accept the broader scope of these variances and the nexus there to the broader conditions on the ground. But I would say this, and as we live and we learn, that in matters of this type of large amount of variances in the future, to remove this discussion, it might behoove all to make the nexus between these even more absolute. So that can be done. But I believe, though the words of the opinion of the prior, which were beautifully written by a board member who has a far more talented pen than I, as I remember how things were brought, they were more generally brought, but I think construed more specifically, if that makes any sense. So I think that's where I come out on these, if that makes any sense.
A couple other questions that were raised before us. One is whether the allegation of the sewer pumping station is a self-created hardship as a factor. Did anybody look at that?
I did. I did. And and I came down on the fact that I believe it's not. It sort of is, but there's a lot of governmental, meaning county input and things of that sort that goes into that as well. You just you don't get to do that without any input and supervision by the powers that be. Um, so though there is some input, I believe that it's not completely self-imposed because there is something to say in it. Maybe I'm wrong in articulating it that way, but that's the way I believed it to happen.
And the other issue that the community raised had to do with the question of the regulations affecting this property differently than other properties in the zone, since all of the justifications for Patapsco Glen 1 and all of the unique characteristics are shared with this case. Both parties cite Dan Mountain.
I thought as a great issue that it made you go, and then the review of the Dan Mountain, um, to me, says that both parties kind of twisted it to kind of mean what they thought they was going to mean. But I do not believe Dan Mountain precludes variance relief because there's similar in the next spot. To me, that's just not what was meant by the Dan Mountain decision. So, though it's a very interesting thought, and I applaud its application, I am not convinced that that is really the interpretation or holding of that case that would preclude relief happening for these adjacent properties.
I agree, related to Dan Mountain. Plus, there are some differences here too. I mean, there's additional, I mean, where the gas line cuts across is different, obviously, makes it a little more unique. The pumping station being there, the tree itself, all of those things, I think, but I would agree with, Mr. Belt regarding Dan Mountain that, and further see that there are some other things more specifically unique to this than the adjoining property.
Were there other issues that we have not discussed?
I think we discussed a lot of issues.
I agree.
All right, so just to go back through these, we will be granting based on a majority, V1, V2, V3, V5, and V7, and denying V8. V4 and V6 were not in play.
Correct.
Yes, that's what I have.
Deborah, I'm sorry, just so I'm, Deborah, wasn't there, what's the ones that you were on board, the specific ones?
Those specific ones that I agree with you both are V2, V7,
That's
and
right.
V8.
2, 7, and 8.
2, 7, and 8, we are unanimous.
Okay.
1, 3, and 5, not so much. I disagree.
All right, well, I think we have done what we're supposed to do.
Okay.
And we'll figure it out from there.
Should we reconvene to discuss assignments here?
I-
You're,
yes.
we will end this deliberation, go off the record, and then we can ask Ms. Connington to put us back in for a brief meeting on how we're going to handle this.
Great. And if Miss Cannington's there, if she could send the invitation to my regular email, that would be one less step I have to do.
Thank you.
Also to mine, Sonny, please.
All right, thank you. Signing off.
All right.